Introduction to Law and Legal Issues in Athletic Training. Legal considerations. Injury problems have grown to such proportion that it is firmly entrenched in most American courtrooms. Lawsuits are increasing in frequency, and damages awarded are relative to the injuries sustained in sport and physical activity. People involved in the delivery of health care are accountable for their actions. A tort is a civil wrong done to an individual whereby the injured party seeks a remedy for damages suffered. An act of omission is when an individual fails to perform a legal duty. For example, failure to warn athletes of the potential risks associated with participation, or failure to assess a reported injury. An act of commission is when an individual commits an act that is not theirs to perform, or commits an act that is their duty to perform, but they perform it incorrectly, leading to injury or harm. For example, distributing prescription medication, or failing to follow a physician's orders. These actions are measured against a standard of care provided by individuals who have a direct duty to provide that care. The standard of care is measured by what another minimally competent individual educated and practicing in your profession would have done in the same or similar circumstances to protect an individual from harm or from further harm. This is dictated by the profession's duty or scope of care. An individual acting as an athletic trainer will be held to the standard of care expected for an individual holding the credential of a certified athletic trainer. An individual acting as a physician will be held to the standard of care expected for an individual holding a medical license as a physician. The scope of care outlines our role and responsibilities of the individual in that profession. This is determined by the role delineation study. This delineates what should be learned in the professional preparation for the individual. The athletic training educational competencies define the educational domains used in preparing entry-level athletic trainers, and each domain is then further defined by a set of cognitive, psychomotor, or affective competencies. And these include risk management, assessment and evaluation, acute care, general medical conditions and disabilities, pathology of injury and illness, pharmacological aspects of injury and illness, nutritional aspects of injury and illness, therapeutic exercise, therapeutic modalities, health care administration, professional development and responsibilities, psychosocial intervention and referral, and diversity, equity, and inclusion. Clearance for participation. The final authority in determining participation status is the supervising physician, not the athletic trainer. It is important to understand your role as an athletic trainer and how your physician can help support you, particularly with these legal considerations. We operate under the direction of a physician at all times. Negligence is a failure to carry out a legal duty. Participants assume some inherent risk, but do not assume the risk that the professional will breach their duty of care. Negligent torts may occur as a result of malfeasance, misfeasance, or nonfeasance. Malfeasance occurs when an individual commits an act that is not their responsibility to perform. For example, if you suspect a neck injury and remove a football helmet, you potentially could be liable, unless this is part of your standard operating procedures and you have been trained in this area. Misfeasance occurs when an individual commits an act that is their responsibility to perform, but uses the wrong procedure or does the right procedure in an improper manner. For example, if you suspected a neck injury and improperly secure the head and neck region to the rigid spine board, you could be held liable. Nonfeasance occurs when an individual fails to perform their legal duty of care. For example, if you suspect or should have suspected a neck injury and failed to use a rigid backboard to stabilize the individual, you could be held liable. Malpractice. This occurs when an individual commits a negligent act while providing care. There is liability generating conduct associated with an adverse outcome of patient treatment. Gross negligence occurs when an individual has total disregard for the safety of others. There is a specific set of criteria that the individual must prove in order for negligence to be proven in court. There has to be a duty of care. There has to be a breach of that duty. There must be harm. This could be pain and suffering, permanent disability, or even potentially loss of wages or future earnings. And the result of that harm has to be a direct cause from the breach of duty. All of these things must be proven in a court of law in order for an individual to be found guilty of negligence. If any one of these things is missing, then we will not be found negligent. So, how do we protect ourselves from negligence? There are some implicit expectations. So, for example, we should be treating our patients with respect and operating with the highest standard of care. Treating individuals with respect may be informed by our morals and ethics. We should be following policies and procedure manuals and standard operating procedures. The National Athletic Trainers Association role delineation and KD competencies can help us to make sure that we are up to date with the newest techniques and trends in athletic training. Although these may not set the standards in all states, they're a good reference to keep in mind. Additionally, making sure that we're familiar with position statements or official statements from good organizations such as the National Athletic Trainers Association, the American College of Sports Medicine, and the NCAA. This is important, so we're going to review it again. In order for negligence to be ruled in a court of law, the injured person must prove that there was a duty of care, that that duty was breached in some way, that there was harm, whether pain, suffering, permanent disability, or loss of wages, and that that resulting harm was the direct cause from the breach of duty. When we look at it this way, it might seem neat and clean. Negligent lawsuits can take years to work through, and you can be reported to the Ethics Board of the NATA at the same time. You may also be reported to your state licensure association if someone suspects negligent activity. So, looking at these criteria, there has to be conduct. Did the person act or did they not act? The thoughts, attitudes, or intentions of the individual are not relevant. There has to be a duty. Look at your job description. When you take on a job, who do you have a duty to treat? Do you need to treat the people in the stands? What about the visiting team? How about the coaches? What about the individuals that are officiating the game, such as referees or umpires? Who are you expected to care for? What is your competency? And then abandonment. Abandonment, once services are provided, the patient must agree or voluntarily terminate the relationship, or a substituting practitioner could be charged. So, for example, let's say an individual is having a heart attack and you leave them to go get an AED. That would be considered abandonment. The better course of action would be to ask somebody else to go get the AED while you remain with the patient. Once you've started caring for an individual, the only way you can leave is if you transfer care to another individual with either the same or higher level of care as you can provide. The standard of care. Do we perform our duties as another competent athletic trainer would under the same circumstances? Causation. The individual must prove that the breach was the legal cause of the injury. Was it the actual cause? The actions were a determining factor in the damage. This may be a shared responsibility between you and the athlete who is injured, or it can be the proximate cause. For example, was the injury foreseeable? And then the damage. The individual must prove suffered damages. This could be physical, emotional. The individual that was injured must also prove that there was some sort of damage loss. This could be the loss of function, employment, income, or some other loss for that individual. But there have to be damages or some sort of loss that was suffered by the individual. Again, all of these factors must be proven in order to be found guilty of negligence. Malpractice. Liability generating conduct associated with adverse outcome of patient treatment is considered malpractice. Malpractice may be the result of negligence, failure to obtain consent, intentional conduct on the part of the professional, breach of contract, use of a defective product, abnormally dangerous treatment, failure to prevent injuries by allowing an athlete to participate when they are not medically cleared, failure to have an ambulance or emergency action plan, failure to identify a condition, or failure to examine an athlete properly after an injury. Our legal liabilities, athletic trainers, and even coaches should be proactive and take steps to limit the risk of litigation. Failure to warn. We should inform potential sport participants of the risk for injury during sport participation. Many times, this is done before an individual even participates in the sport, usually during the pre-participation physical exam. Participants and parents of minor children should learn that risks for injury exist and must understand the nature of the risk so informed judgment may be made about participation. Comprehending the nature of the risk is determined by the participant's age, experience, and knowledge of pertinent information about the risk. There are a variety of methods that we can use to warn participants, including pre-season meetings, posting warning signs, and even requiring protective equipment. Is to look at the foreseeability of harm. This exists when danger is apparent or should have been apparent, resulting in an unreasonably unsafe condition. These factors may be identified during regular inspections of gymnasiums, field areas, swimming pools, safety equipment, and even athletic training facilities. Some examples may be unpadded walls under basketball hoops, slippery floors near a whirlpool, or even failure to follow universal safety precautions. An unsafe condition should be identified and reported as soon as possible. I would encourage you to report things in writing. Therefore, you then have documentation to help support that you did actually identify and report these unsafe conditions. Informed consent. Informed consent implies that an injured party has been reasonably informed of the needed treatment, possible alternative treatments, and the advantages or disadvantages of each course of action. Valid consent can only be obtained from an individual who is competent to grant it. In the case of children, that would usually involve a parent or legal guardian. In the case of adults, individuals over the age of 18 can provide informed consent for themselves if they are of sound mind and body. Authorization to treat in the absence of a parent or in the event of an individual is physically unable to consent to treatment should be obtained in writing prior to the beginning of sport participation. Sometimes there are exclusionary causes. This should identify conditions that will not be treated by the athletic trainer. For example, we may only treat injuries that are associated with direct participation in sport. It is important that we are sensitive to cultural and religious beliefs and practices and honor those practices by providing appropriate care consistent with the wishes of the individual. For example, in some cultures, a woman may be taught not to undress or bare skin in the presence of a man other than her husband. In this case, it would be necessary to refer the athlete or the patient to a female athletic trainer. Additionally, in some religions, they do not believe in invasive therapy, so things like blood transfusions or anything that pierces the body may be considered an inappropriate treatment. There are some therapeutic interventions which we'll explore, like dry needling, that actually penetrate the skin. So for some of these individuals, they may not consent to this type of treatment. So it is very important to explain and to communicate with your patients on a regular basis to make sure that they are providing you with informed consent. If we do not have informed consent, we could be potentially charged with battery. Battery is any unpermitted or intentional contact with another individual without their consent. Other legal liabilities. Refusing help. Regardless of the reason given to refuse help, the conscious and medically competent individual has the right to refuse treatment. An exemption may occur when failure to move the injured party may result in an increased risk for further injury to the injured party or to others in the vicinity of the victim or the accident. For example, during an organized bike race, several bikers collide and fall onto a busy road. It would be appropriate to move the injured individual off the road so as to not endanger themselves or any approaching bicyclist. Product liability. We have implied warranty. Manufacturers have a duty of care to design, manufacture, and package safe equipment that will not cause injury to an individual when the equipment is used as it was intended. There is expressed warranty. This is a written guarantee that the product is safe for use. In football, there is an implied warranty that if fitted and used properly, a helmet can protect the head and brain from certain injuries. Strict liability. The manufacturer is liable for all and any defective or hazardous equipment that unduly threatens an individual's personal safety. We also have the National Operating Committee on Standards for Athletic Equipment, also known as NOCSE. They establish minimum standards for football helmets. Any alteration or modification to any protective equipment may negate the manufacturer's liability. Confidentiality. This is a release of any medical information that must be acknowledged in writing by the sport participant, or if under the age of 18, their parent or legal guardian. If permission is given to release information, it should identify what information can be shared with an individual other than the patient's physician. Information may be provided to coaches and parents, but it should be on a need-to-know basis only and given with the full knowledge and consent of the athlete, supervising physician, and the athletic trainer. Confidentiality should also extend to all medical records kept within the confines of the athletic training facility. If the threat of litigation exists, many athletic trainers rely upon certain conditions to strengthen their case. Some of these are assumption of risk, the Good Samaritan defense, and comparative negligence. We'll start with assumption of risk. We should require athletes to sign an assumption of risk form. This is not the same as a permission slip to participate in athletic activity. By signing the form, the athlete acknowledges that the material risks and appreciates, knowing and reasonably anticipating that other injuries and even death are possibilities associated with athletic activity and that they are voluntarily participating in the activity, and that they assume all the risks for injury or even death due to their participation. The assumption of risk form does not assume the risk that the professional will breach their duty of care, though. Good Samaritan laws. These laws vary from state to state, but in general, they provide immunity for an emergency first aider who is acting during an emergency, acting in good faith to help a victim, acts without expected compensation, and is not guilty of any malicious conduct or gross negligence towards the injured party. These laws are easy to get around and should not be relied upon by rescuers who erroneously believe that the laws will protect them from litigation, regardless of their actions. Also know if you have a duty, such as an employment situation, Good Samaritan laws do not apply. You now have a duty to act. The Good Samaritan laws only protect you in the cases where you do not have a duty to act. Comparative negligence. This refers to the relative degree of negligence on the part of the plaintiff and the defendant, with damages awarded based on each person's carelessness. For example, if the athlete was found to be 30% at fault for their own injury, this would be contributory negligence, and the defendant was 70% at fault. On a $100,000 judgment, the defendant would be responsible for $70,000 in damages, and the athlete or plaintiff would assume the equivalent of $30,000 in damages. So how can you reduce your risk of litigation? Establish good working relationships with athletes, parents, and coworkers. Establish policies and procedures regarding how athletic training facilities and coverages will occur. Develop good quality emergency action plans and have them reviewed by legal. Know the medical history of your athletes and update this regularly. Maintain adequate and up-to-date documentation and records. Have a detailed job description. Obtain written consent relative to providing care. Maintain confidentiality. Exercise caution with regards to medication distribution and modality use. Ensure equipment and facilities are safe. Follow physician's orders, particularly when dealing with participation of an athlete. Purchase personal liability insurance and don't rely on your employer. Know your scope of practice. Use common sense. Understand your duty of care. Take steps to reduce your risk of litigation and know the NATA position statements and consensus statements. Develop standard operating procedures and practice with the highest standards of care. Professional liability insurance can protect us against damages that may arise from injuries occurring on school property. This covers against claims of negligence on the parts of individuals. I would not advertise that you have your own professional liability insurance, but it can be a great way to protect yourself, and it is additional insurance policy beyond that of your employment contract. You've worked way too hard to get where you are to have somebody else take it away. You want to protect yourself. Professional liability insurance is usually fairly cheap unless you are an independent contractor or you are working per diem. Then it can get very expensive. In those cases, it's even more important that you have personal and professional liability insurance, as you are not relying on an employer to help with that liability insurance. You might want to review the Texas Practice Act and other states' practice acts. You can find those on the Board of Certification website.